Hey guys, I wanted to make this video so I can explain the importance of why you should respond anytime you receive a letter from a third-party debt collector. Now, I first want to say that this is not legal or financial advice. All right. I want you guys to do your own due diligence. You can take the information that I provide, and do your own further research to see what information will help you in your specific situation. All right. Now, you may not always receive a call from a third-party debt collector. Sometimes you will just get a letter in the mail. Sometimes you may just see an account on your consumer report. For the sake of this video, we're going to say that you receive a phone call first. Also in this video, I am not going to go over, violations in these letters. All right. It's just going to be very general to help people who get these letters know what their first step should be in disputing and requesting validation. All right, so let's get into it. So you get a phone call from Dynamic Recovery Solutions claiming that you owe $434.52. Never agree to anything over the phone or in writing, and never admit to anything over the phone or in writing. When they contact you, you can let them know that you don't know what account they're talking about, and whatever claim that they have against you, or whatever claim that they are alleging you owe, they need to send you something in writing, and that all future correspondence should be done in writing. You no longer want them to contact you by phone. Okay. Now you will eventually need to send them something in writing, your cease and desist, which we'll go over later in the video. But at least tell them now verbally not to contact you by phone, that all correspondence should be done in writing going forward. All right. Now, if they continue to call, to contact you, right, make sure that you're documenting everything. If they leave you a voicemail, do not delete the voicemail, save the voicemails. Okay. So within 5 days after they contact you, they are supposed to send you a letter. Okay. Now, from Dynamic Recovery Solutions, this is what their letter looks like. Eastern Account Systems of Connecticut, this is what their letter looks like. Now, there is required information, which is this section here under important, and this section that's in that box. Okay, and we're going to go over that in just a minute. So you get this letter and it says it's from Dynamic Recovery Solutions. They are claiming the original creditor is Phoenix Emergency Medical of Broward, and they are claiming the current creditor is Pendrick Capital Partners, and you allegedly owe $434.52. Our client, Pendrick Capital Partners, has purchased, so you want to remember that word, purchased, your account from Phoenix Emergency Medical of Broward. We, Dynamic Recovery Solutions, have been asked to contact you regarding your past due account. They're already, trying to tell you that it's past due when you didn't even know it was past due. I'm sure you probably didn't even know that you had an account with Pendrick Capital Partners or Dynamic Recovery Solutions. Our client has not received payment as of the date of this letter. Therefore, the account has been placed with our office for collection. Now, as you can see, they give you these 3 payment options. They want to try to entice you to make a payment. They even tell you that these offers are not your only options. They take pride in working with consumers regardless of your current financial position. So they want to try to let you know that they are willing to work with you, and establish some kind of payment arrangement or a payment. All right. Now, I want you guys to think about this. Phoenix Emergency Medical of Broward is not the company that is contacting you right now. It is Dynamic Recovery Solutions. All right. And you need to think about, what business did you do with Pendrick Capital Partners or Dynamic Recovery Solutions? I'm assuming probably none at this point, right? So why would you feel that you owe them? Some people will say, oh, well, I really did go to the emergency room and I owe it, so I'm just going to pay, the 800, what is it? $108, because it's such a great deal, right? If Dynamic Recovery Solutions had proof that you owed $434.52, why would they then be willing to accept a lesser amount? That would be my first thought. Why are you willing to accept less money if you feel that I really owe you $434? Okay, that would be my first thought. Now, some people will say, well, let's say it's on your consumer report. And, they say, well, I want it removed from my consumer report, so I'm just going to go ahead and pay it. And they may do what's called a pay for delete letter. So a pay for delete letter is basically you would write a letter to Dynamic Recovery Solutions in this situation, telling them I will pay you X amount of dollars if you remove it from my consumer report. But again, now you have now just created an agreement with them, agreeing to pay them a certain amount of money for them to remove it. You never did that before, right? You never established any type of agreement with them before. So why now do you feel like you owe it only because it's on your consumer report? It's on your consumer report because you never disputed it. Okay. Some people will say, well, I don't want it on my consumer report, so I'm just going to pay them something. And then guess what? They may pay them something, and then it may show up on their consumer report. And then they're wondering, why is it on there? Well, it's on there because further on down in this letter, it tells you that if you don't dispute it within 30 days, they assume that it's valid, right? So if you're paying on it, then they can only assume that you are in agreement that you owe it, and you owe whatever amount that you pay them. So then if you pay it, that means you're in agreement with it. So then why wouldn't they put it on your consumer report to further hinder you to be able to get credit that is yours, right? So let's go down and look at this letter. Okay, this little section here. And on this letter, this section that says important. Unless you notify this office within 30 days after receiving this notice that you dispute the validity of this debt or any portion thereof, this office will assume the debt is valid. Assume. Assume. You have to dispute it, or they will think that you are in agreement with whatever amount they're claiming you owe. Even if this amount was $5,800, and even if that is the incorrect amount, if you're not disputing it, they're going to assume that you are in agreement that you owe $5,800. Okay? If you notify this office in writing within 30 days from receiving this notice that you dispute the validity of this debt or any portion thereof, this office will obtain verification of the debt, right? Obtain verification of the debt, or obtain a copy of a judgment and then mail you either a copy of the judgment or verification. Obtain means they don't have the information. They don't have the documentation. They don't have the verification. They don't have a copy of a judgment. They have to get the information, in this case, from Comcast. In this case, they would have to get it from Phoenix Emergency Medical of Broward. And as you can see, this says this communication is from a debt collector. This is an attempt to collect a debt. Any information obtained will be used for that purpose. And theirs, even though I apologize because it's merged into one line, it says, unless you notify this office within 30 days after receiving this notice that you dispute the validity of this debt or any portion thereof, this office will assume the debt is valid. If you notify this office in writing within the 30 days after receiving this notice that you dispute the validity of this debt or any portion thereof, this office will obtain verification of the debt or obtain a copy of a judgment. Then it says, upon your written request within 30 days after receipt of this notice, this office will provide you with the name and address of the original creditor if it's different from the current creditor. This letter tells you the same thing. If you request this office in writing within 30 days after receiving this notice, this office will provide you the name and address of the original creditor if different from the current creditor. This is an attempt to collect a debt. Any information obtained will be used for that purpose. This communication has been sent by a debt collector. So you know that they are a debt collector, so you know that they fall under the FDCPA, Fair Debt Collection Practices Act. Same with this letter. This communication is from a debt collector, right? This section is required by law. They have to tell you this information. If you go to 15 USC 1692G, under A, it tells you notice of debt contents. Within 5 days after the initial communication with the consumer. So when they made that phone call to you, within 5 days, right? Within 5 days, they have to send you something. Okay. Within 5 days after the initial communication with the consumer in connection with the collection of any debt, a debt collector shall send the consumer a written notice containing the amount of the debt, the name of the creditor to whom the debt is owed, the statements that you have 30 days to dispute it or they will assume that it's valid, 30 days that you can dispute the validity of the debt or any portion thereof, and they will obtain verification or a copy of a judgment. And within the 30 days, they will provide you the name and address of the original creditor if it's different from the current creditor. So all of that information is required. Okay. Let's go back to the first letter. As you can see, they have additional information that is not included on this letter. Okay. So it says the law limits how long you can be sued on a debt, right? Statute of limitations. It tells you because of the age of your debt, Pendra Capital Partners and Dynamic Recovery Solutions will not sue you for it. So they are not going to come after you. But it says, and Pendrick Capital Partners will not report it to any credit reporting agencies. Pendrick. But it doesn't say that Dynamic Recovery Solutions won't report it. So that's why I say it's very important that you are disputing within 30 days so that they do not report it onto your consumer reports. Now, if they happen to report it, because let's say it's after 30 days, I do not want you guys to feel discouraged like it's been after 30 days and now you can't dispute it. You can still dispute it after the 30 days. Now, just know that it may be a little more time consuming because now you have to try to get it removed from your consumer reports, but please don't feel like you cannot dispute it because it's been over the 30 days. Okay, you can always dispute it. Okay. So then it's telling you, even if the statute of limitations has expired, you may choose to make payments on the debt. Now, I don't know why anybody would choose to make payments on it once the statute of limitations has expired, but to each their own, right? Now they're warning you, okay? They are warning you. Be aware. If you make a payment on the debt, admit to owing the debt, promise to pay the debt, or waive the statute of limitations on the debt, the time period in which the debt is enforceable in court may start again. So this is why I said in the beginning of the video, it's very important when they call you that you do not admit or agree to anything over the phone or later on in writing, right? Because they will use it against you and try to pursue further action. Okay. And what happens is a lot of these people, get these letters and we don't respond. And then these companies go and try to file a lawsuit. We don't respond to the lawsuit and they're able to get a default judgment because, these things are not taught to us. Okay. These things are not taught to us. So it's very important that we are disputing this information. Okay. So how do you dispute it? You send them a letter. Now, I'm quite sure if you go onto Google and type in debt validation letter, there will probably be hundreds, if not thousands of letters that you could use. I really don't recommend people use templates because typically people will just put in their information and then just send it off without really reading the letter. And I really want you guys to understand what is in the letter and what it means. Okay. So you could go on to let's just say we'll go on to consumerfinance.gov. Okay, consumerfinance.gov. This is the Consumer Financial Protection Bureau's website. If we click on consumer education, consumer resources overview, and we scroll down to debt collection, it'll tell you here, let's go down a little further to how-to guides, how to reply to a debt collector. And please go on this website and just look over their website. They have a lot of resources available to you for free, okay? It tells you here, all right, when a debt collector first contacts you in writing regarding a debt, it must provide you a written notice that has certain legally required information, right? That's this here, the validation of debts. This section here is what they're talking about, that it's required, okay? If the collection agency first contacts you by phone, insist that they contact you in writing, right? We already established that, okay? So then you are able to download one of these templates, all right? And again, I just talked about templates, but I'm just going to show you one for the sake of this video, all right? So it's going to tell you basically, how to fill it out, and it'll even tell you, make sure that you edit it to fit your situation, delete any parts that don't apply to you, okay? So it tells you that information in here. So I'm not going to go through the entire letter. You can, review it at your leisure. You would put your name here, debt collector's name here, debt collector's name here, and then how they contacted you, when they contacted you about what debt. Okay. Now, this is why I tell you not to use templates. If you're going to use a template, all right, then make sure that you are reading it and understanding what the words mean. Okay, so I'm not going to go through this whole thing, but it's asking name and address of the creditor to whom the debt is owed. If it's different, we want the information, right? Here it says provide verification and documentation that there is a valid basis for claiming that I am required to pay the debt to the current creditor. For example, can you provide me a copy of the written agreement that created my original requirement to pay? Now, this is my thing. I don't really care, and I'm talking personally, okay? I don't care about any type of agreement that they are going to send me that says that I allegedly owe, in these two examples, Comcast and Phoenix Emergency Medical of Broward. All right. Why don't I care? Because those two accounts are not contacting me about the debt. They have written the debt off, and those letters are not from those two companies. Those letters are from third-party debt collectors. And I know I didn't get into any type of agreement nor sign any type of documentation with those third-party debt collectors. So I don't really need any, documentation from a company that I know I didn't do business with. If you're claiming that I now owe you, I want you to provide me the documents between you and I, right? So here it says provide verification. So what is verification? So let's go to the Black's Law Dictionary. Now, this is the 8th edition. They have, many different editions. So you can look through all of them if you want, but this is just the 8th. Verification, a formal declaration, right? Made in the presence of an authorized officer such as a notary public, meaning that they need to make a formal declaration in front of a notary public, meaning it has to be notarized, okay? Or under oath, but not in the presence of such an officer, whereby one swears to the truth of the statements in the document. So they need to swear under oath. It doesn't have to be notarized, but they have to swear under oath, where a lot of times they'll say, I swear under oath under penalty of perjury that these statements in this document are true, right? That's what this verification means. So that third-party debt collector needs to send a formal declaration, either notarized or under oath, that the statements in the document that they send are truthful. Now, will they be able to really provide verification? Probably not, because they're unaware of how that company keeps their records. They were not there when the transaction allegedly occurred, so they can't really speak to the truthfulness of what happened, right? Verify, to prove to be true, to confirm or establish the truth or truthfulness of, to authenticate, to confirm or substantiate by oath or affidavit, to swear to the truth of. So when you're asking for verification, this is what you're asking for. Not just, oh, send me some statements of, an account that I had with Comcast, or if you had some other type of account where you signed a promissory note and you're send me a promissory note. No, you want verification as defined, okay? Then it talks about documentation. So provide verification and documentation. Now, I wouldn't put documentation, I would put documentary evidence. Okay, what is documentary evidence? We're going to go to 15 USC 44. We click on that. Documentary evidence includes all documents, papers, correspondence, books of account, and financial and corporate records. Now, typically, when you ask for documentation, they're going to send you what? Documents, maybe a past due letter, a statement, like a promissory note, those type of documents, right? Documents, papers, correspondence. Do you think that these people want to send you books of account and their financial and corporate records? Definitely not. Books of account, ledger, a book or series of books used for recording financial transactions in the form of debits and credits. So do you think that these companies want to send you their books showing debits and credits for an account that they purchased? You were never in agreement to pay them. Yeah, they're not trying to give you that information. Okay, but this is why you want to put certain information in, and this is why you want to read through the letter so you are understanding what the letter is saying. Okay, and like I said, I'm not going to read through all of it, but a copy of a statement, where there are additional interest fees, all of that, I want to know all that too, right? And then it tells you here details about your authority to collect this debt. So is this a licensed debt collector? Is this debt collector licensed to collect in your state? These are things that you need to know. Okay, then you can put your name and you'll send it off, right? Now, when you send it off, you want to first make a copy, right? So save a copy to your computer. All right, you want to keep an original, and then you want to mail a copy, certified mail return receipt, all right, to the third-party debt collector. Now, a lot of times people will also send a cease and desist, right? You do not want them to contact you anymore. And as I said in the beginning of the video, you do have to send it to them in writing, right? Even though you told them verbally on the phone, you have to send it to them in writing. So here we go to 15 USC 1692C. And you see we're at C here, but we're going to scroll down to C, ceasing communication. If a consumer notifies a debt collector in writing, right, that the consumer refuses to pay a debt, or that the consumer wishes the debt collector to cease further communication with the consumer, the debt collector shall not communicate further with the consumer with respect to such debt except, and these are those exceptions. All right. So the debt collector has to notify you that they are no longer going to collect on the debt, or they have to contact you to tell you, yeah, we're going to try to pursue further collection activity, meaning they will try to file a lawsuit or something like that. Okay. So sometimes when people send the debt validation letter, because they are wanting documents, from the debt collector, that those verification and documentary evidence, All right. At that time, they may or may not send a cease and desist. It's really up to you. Okay. Because as you can see here, even if you send them the cease and desist now, they can still send you the information that they are no longer going to collect on the debt. And really, that's all you want, right? You just want to know that they are no longer going to collect on the debt. Now, people who want to go after the third-party debt collectors, right, for a remedy, for money, they may want those documents because those documents will be able to be used as exhibits when they send their, bill of particulars, right? So it's up to you on what you want, right? If you just want to be done with it, then you can just send your cease and desist with it. Or you don't have to. Like I said, it's up to you on what you want to do. Okay. But as you can see here, even if you send them a cease and desist, they are able to contact you to let you know either they are going to stop collection or they are going to pursue collection activities. Okay. So what I do is I would send the documents, certified mail, return receipt. All right. You save your copy. Okay. And then you're going to go to the CFPB website. I'm going to go back to the original, homepage. Okay. And this is where you're going to submit a complaint. Now, the reason you want to submit a complaint is because number one, the third-party debt collector may not respond to you. Okay. But they will respond to the CFPB. And you want that finalization. You want some kind of documentation from them that they are no longer going to collect on this debt. All right. You want it for your records. Okay. The more people that complain on these third-party debt collectors, it will help everybody because then the CFPB can then go after those third-party debt collectors. So the more people that are filing these complaints, the better it is for everybody. All right. So you're going to go on here and you're going to file your CFPB complaint. So submit a complaint. And again, I just use this as a tool. It's basically just another way that I've proved that I have sent the third-party debt collector the dispute and the request for validation and verification, right? So once you're on this page, you're going to just scroll down, ready to begin, and you're going to start a new complaint. Okay. Now you are going to have to register and create an account. All right. If you do not want to give your personal email, just create a new email that you would be using just for these situations. Okay. You want to create your account because then you're able to track the status of your complaints. Okay. So you'll sign up and then you'll be able to submit a complaint. And I'm not going to go through submitting a complaint right now, right now, but I will show you what one looks like. So you would go on to their website and you would, fill out your information. It's going to ask you different questions and you're going to select the appropriate choice. Then there's going to be a box where it has your complaint and where it says, please review attached documentation. This would actually be a box that you could type in. And you could just type in this, please review attached documentation, please see attached, whatever you want to put. Or if you have your letter, right, you could copy it and then paste your letter into that section. Or you could just type in, please see attached, and then you would attach your documents that you mailed. All right. Now, as you can see, this was submitted to the CFPB. So this was created on 2/8. And for some reason, they didn't send it to the company until 2/25. All right. But then they'll give you an update, right? So we've sent your complaint to this company. We'll let you know when they respond. So they sent it on the 25th. And you see on the 26th, the company responded. Per your request, Eastern Account System has ceased all collection efforts. Follow-up may be required with the original creditor. Basically, they are going to send it back to, in this situation, Comcast, right? Eastern Account System. So they're going to send it back to Comcast. And then now Comcast may try to sell it to another third-party debt collector. And if that's the case, you just have to go through all of the steps again. So you have to send another, dispute letter to this new third-party debt collector, and then file your complaint with the CFPB. Okay. But here is your documentation right? That they have ceased all collection efforts. Okay. Now, sometimes, they might have, please see attached, and then they would have something, attached that you could download that may be on their company letterhead. Regardless if it's on their company letterhead or it's just typed in like this is your evidence. So if they try to be slick later on and, try to pursue a lawsuit, then guess what? You have your evidence that they ceased all collection efforts, right? This is your evidence. So you want to keep this. All right. So just to generally go over the steps again, whether you receive a phone call, whether you receive a letter, or whether it's on your consumer report, you want to not admit or agree to anything and you want to dispute it. All right. So you want to dispute it in writing. All right. Then once you mail out your documentation, you want to upload and file a complaint with the CFPB and wait for either the third-party debt collector to respond to you or to respond to the CFPB so that that account, has been finalized. So those are the initial steps. I hope that you found the information useful. Again, please, go and do your own research. Please look at the other codes that may be more specific to your specific situation. But this is just a starting point. So if you have any questions, please feel free to leave it down in the comments and I will do my best to respond to everybody.